Hello there, my name is Richard Bonnar. I'm chair of DLA Piper's Brexit Committee. I'm here today with Camilla Macpherson, our Brexit Counsel, and we're going to talk to you about the Great Repeal Bill. The Great Repeal Bill is going to do three things. First of all, it's going to provide for the repeal of the European Communities Act and European-derived legislation. Secondly, though, it's going to provide for the conversion of all EU-derived legislation into UK domestic law. And thirdly, it's going to provide for powers to be given to ministers to deal with all the consequential changes that arise as a result. But why is the government doing this? The reason the government is doing this is black hole. If the government did nothing, then all that EU regulation and directives and so on, which you're very familiar with, would disappear when the UK leaves the European Union, and there would be no regulation whatsoever. Camilla and I are going to talk about three things today. First of all, we're going to talk about the scale of this challenge, both for Parliament and for us as a legal profession and as a law firm. Secondly, we're going to talk about the constitutional issues. And thirdly, we're going to talk about the really interesting issue of ECJ case law. So Camilla, is this a simple task, or do you think this is quite a complicated task?
Oh, it's a huge task. It's a huge task. There's some specific areas where you can't just drop EU legislation into UK legislation and hope it's going to work, because it won't. So an example would be if an EU regulation refers to some EU agency or EU organisation that you need to apply to for permission, or you need to share information with. The UK probably isn't going to want to continue doing those things post-Brexit. So those kinds of regulations need extra work. There's also a scale thing. There's something like 12,000 EU regulations in force and tons of other bits and pieces of EU law that form part of UK law. And the other really complicated issue is a timing one, which is that while the politicians are negotiating about what Britain's exit from the EU will actually look like, the drafts people are going to have to be playing catch up against that. So nothing will quite be finalised until Parliament, until the politicians have finished agreeing the exit deal.
So let's talk about the second issue. There's been a lot of commentary on the bill and speculation that amounts to a power grab by ministers. What do you think?
Yeah, I don't think that's completely fair. There's a huge amount of work that needs to be done to get all this legislation on the books before the UK leaves. Government is saying there'll be at least 1,000 statutory instruments. So the way they're dealing with this is through delegated powers, whereby Parliament gives government ministers powers to change legislation. Now that is a constitutional issue because Parliament is the driver of legislation in the UK. So there'll have to be limits put on what government can do in time and scope. Government will have to limit itself to the more mechanical changes, not the big policy changes. But there are bound to be arguments about, there's blurred lines there about what's the policy change, what's the mechanical change.
Well, we've all been there as lawyers, haven't we? One man's minor change is another man's major decision, isn't it?
Exactly, exactly. And the other interesting thing about a statutory instrument is that the courts can declare them invalid. So that means that if government goes beyond its powers in some respect, parties can go to the courts and ask for them to be declared invalid. And the other issue is, the less scrutiny there is, which is the reality if something's a statutory instrument rather than going through the full parliamentary process, the more chance there are that there's errors or oversights or things that just don't quite work.
So there's quite a trade-off, isn't there, between speed and volume and scrutiny and getting it right.
Exactly.
Let's talk about the third thing, which is the role of the ECJ. This has been quite a political football, hasn't it? But as lawyers, we're very used to dealing with ECJ-derived case law. Is that all going to disappear?
Yeah, I think quite a lot of people assume that it is all going to disappear, but it's not quite the case. So the way it's going to work, quite complicated, but to the extent EU regulation is dropped into UK domestic law and that comes to be interpreted by the courts, there's no place for the ECJ anymore in that. There's no referrals to the ECJ, perhaps maybe in narrow spheres, but broadly not. However, when the UK courts come to interpret a piece of EU-derived law that's now part of UK domestic law, they'll have to do so in accordance with any relevant ECJ case law as at Brexit Day. So as at the day the UK leaves the EU, that's where it fixes what ECJ case law is, and the courts will have to look at it. And it will have the status of a Supreme Court judgment, so quite difficult in practice, though not impossible to overturn.
So lots to think about and lots to look forward to. Well, thank you, Camilla. That was really great and very insightful. The bill is going to come forward around about May, and that will hopefully give us some more insight in terms of how this is going to work. But after that, it's going to be a bit of a roller coaster ride, And as a DLA Piper Brexit Committee, we're going to be working very hard to make sure you have all the information you need. There's lots and lots of information on the DLA Piper Brexit website. Thank you for your attention. We look forward to working with you.